Hello everybody and welcome to the September training webinar. I'm really pleased to have as our training guest this month Paula Hebbard, who is a solicitor at Woodstock Property Law, and you may recognise the name Woodstock Property Law because they are one of the solicitors that do our telephone advice. So welcome, Paula.
Hello, welcome Tessa.
Paula is going to bring us up to date with the coronavirus rules. Unfortunately, she's going to have to do a bit of discussion about the eviction rules. I thought I got it nailed with David's webinar last month, but a couple of days after David had done his webinar, as you probably know, the government went and changed the rules. So Paula's going to talk us through the changes and then go on to discuss other things like viewings and such like. If you want to ask any questions, put them in the chat box. Paula has done some really helpful handouts and I've loaded them up to this system and you can download them. There should be a handouts button somewhere on the delegates bar, so you can download them there. But if you're not able to download them, they will go up on the page where the recording goes on Landlord Law in due course. So welcome, Paula, take it away.
Thank you, Tessa. Well, hello everyone. My name's Paula. As Tessa has introduced me, I'm a solicitor and an owner of Woodstock Property Law. I'm looking forward to today. I hope it's not going to be too painful to listen to me for an hour. But let's crack on. So what we're going to cover today is evictions and notices and what has very, very recently happened. We're going to cover off viewings and inspections. We're then going to talk about repair work and then any questions that you'd like me to answer. So let's move on to section 21 notices. Now, this is in England at the moment. I don't know if anyone remembers. I don't know where the time's gone. It's very peculiar at the moment. But before the 26th of March, it was 2 months' notice. And then between the 26th of March and the 28th of August, it was 3 months' notice. And now, after the 29th of August, it is 6 months' notice. In Wales, to touch on that, before the 26th of March, it was 2 months. Between the 26th of March and the 23rd of July, it was 3 months. And then between the 24th of July and the 30th of September, it is 6 months. We don't know what's going to happen on the 30th of September in Wales, so it's a matter of watch this space. I'm not going to speculate because, as we've probably all seen, the law is changing and evolving very quickly. So just keep a lookout around that time to see if there's any further changes. Now, there is now a new court form on the court website. It was taken down. This was the N5B for accelerated possession proceedings. It's now been put up there. So make sure you use that form. The actual section 21 notice, the form 6A, is now on the government website and that's also been updated. So it's really important that you use that notice going forward. So just get a copy off the government site. To help, the periods in which possession proceedings may be brought under a section 21 notice has been extended from 6 months from the date of service to 10 months from the date of service. Otherwise, if they hadn't have done that, you wouldn't have been able to go to court on any of your section 21 notices at the moment. So just keep in mind, and this is for England, you now have 10 months to go to court on that section 21 notice. If you don't, you will have to serve another section 21 notice. It's worth noting that the 6-month period for England is up to the 31st of March 2021. Then again, we will have to see what happens after that date. If it reverts back to 2 months, if they extend it any further, which they do have the powers to do. I don't think Section 21s are going to be abolished yet. There's discussions that it may happen over the next 12 months. But again, let's watch this space and just deal with what's happening at the moment. So, Section 8 notices. Now, before, mostly it was 2 weeks notice where there were rent arrears. Then it went to 3 months. And after the 29th of August, it is now, for most grounds, it has gone to 6 months. Now, with a Section 8 notice where you're relying on grounds 8, 10 and 11, so those are the ones relating to rent arrears, where there is less than 6 months notice at the date, 6 months arrears at the date of service of the notice, you have to give 6 months notice. However, where there at the time of service of the notice there are not less than 6 months, it's 4 weeks notice. So if it's under 6 months arrears, you need to give 6 months notice. If there's not less than 6 months arrears, it's 6 months. So, sorry, 4 weeks notice. A bit of a tongue tie this. So if you've got 6 months arrears, you can give 4 weeks notice. If there's less than 6 months arrears, you need to give 6 months notice. So just keep that in mind. It's not 2 weeks notice and it's not 3 months notice anymore. Now, in respect of other grounds, you'll see that ground 7 is now 3 months notice. I have put a table together, so you can download that afterwards, which sets out all the grounds and the notice periods that apply in England and Wales. So don't worry about remembering all of this. With ground 7A, which relates to closure orders, that is 4 weeks notice and 1 month's notice for a monthly tenancy. In respect of ground 14, now this is quite a useful ground to rely on at the moment, and it does relate to a person who's residing or visiting the property. It can be a landlord or a person employed by the landlord, and the tenant is causing them nuisance or annoyance, or there's a legal purpose at the property. So when you're relying on ground 14, you don't have to give any notice whatsoever. If you rely on ground 14 and you want to include other grounds such as rent arrears, again, you don't have to give any notice whatsoever. However, it is really important that you obtain evidence. So this can include police reports from the local authority, witness statements from neighbours. So you do need solid evidence. Don't think you can just chuck in ground 14, serve a Section 8 notice and off to court. It doesn't work like that. So make sure you have a very solid case. Now,
can I just chip in here, Paula, and just say that my advice to people is, if you are going to use a ground like that, one of the discretionary grounds where the judge doesn't have to make an order. I mean, if you use Section 21 or the serious rent arrears ground and you make out that ground, you know, you're there. The judge is going to make your order. If you use a discretionary ground, then the judge has a discretion whether they make it or not, which usually means that you're into tenants putting in defences. You've got lots of evidence. It's very complicated. You really need to use solicitors for that. And I would suggest that before even starting it, you get some proper advice, either from Paula's firm or one of the other firms that we have on the telephone advice service, because starting a court claim, it's a bit like getting on a fast train. You know, it's very difficult to get off once you've started. So you need to take proper advice first.
Yeah, I think that's a really valuable point to make. If you can rely on a Section 21 notice on mandatory grounds for possession, always go to court on those notices. The problem we have at the moment is the 6 months notice with a Section 21. And I am receiving quite a lot of calls from landlords who are extremely upset and stressed because their tenants are, you know, drug dealing. I've had one who's a fire starter, and the tenant next door is bedridden, so she's extremely nervous what's going to happen. So ground 14 are in those exceptional circumstances where there are no other grounds that you can rely on, such as mandatory grounds, ground 8, or a Section 21 notice. But certainly, if you have any cases like that and you need some help, feel free to contact me and we can run through those. Now, the other grounds that you can rely on and the notice periods I've put here, I've just made a note here, are grounds 1 to 6, a 6 months notice. ground 9, 12, 13, 15 and 16 are also 6 months notice. And apologies, let me move on here. And ground 17 is 2 weeks notice. So as I say, there is a table that you can download that that has more details on those grounds. So take a look at that.